Hello, I'm Elizabeth Wydra, President of the Constitutional Accountability Center. Thank you for joining us tonight for an important discussion about the constitutional path that has brought us to this moment of reckoning with state-sponsored violence against people of color, and in particular, police violence against Black Americans. This is not a new problem, as many Americans know far too well. But we are at a moment when many of us are having more conversations. More of us are having important conversations that are long overdue. I'm grateful tonight that we are coming together for one of these important conversations, a conversation that will be anchored tonight by a paper soon to be published in the Columbia Journal of Race and Law entitled, "We Do Not Want to Be Hunted: The Right to Be Secure and Our Constitutional Story of Race and Policing," authored by the Constitutional Accountability Center's own David Gans, which you can find on our website, theusconstitution.org. This groundbreaking work could not be more timely or more relevant to understanding America's crisis of discriminatory and violent policing practices. For too long, the Supreme Court has enabled the kind of malignant and unaccountable police practices that killed George Floyd, Breonna Taylor, and so many more people known and unknown to the nation at large. The Supreme Court has never recognized that the 14th Amendment was added to the Constitution against the backdrop of mass arrests and brutal racial violence by the police. Getting this history right is essential to correcting police abuses today. Explaining what the Constitution says about race and policing is critically important to this national moment. Explaining that the principle of Black Lives Matter is at the heart of the 14th Amendment is crucial to this nation and to this moment. I am so honored that we are led off in this discussion by keynote remarks from Congresswoman Ayanna Pressley, who represents the people of the 7th Congressional District of Massachusetts with a grace and ferocity that is unparalleled in the halls of Congress. This freshman member of Congress has risen to national recognition by remaining true to an overarching guiding principle that those closest to the pain should be closest to the power, and that a diversity of voices in the political process is essential to making policies that benefit more Americans. She has used her powerful voice to center the lived experiences of those most marginalized in America. And she works to do something that the Constitutional Accountability Center has at the heart of its mission, making sure that the Constitution's promises of equality and justice are not just promises on paper, but are a lived reality for all. She seeks justice for marginalized groups, and in doing so, she has remembered that justice cannot be rendered without accountability. And that is why, in the realm of policing reform, she's at the forefront of the accountability debate as a lead co-sponsor of the Ending Qualified Immunity Act with Representative Justin Amash of Michigan. The Ending Qualified Immunity Act would end the judge-made doctrine of qualified immunity, ensuring government accountability, encouraging courts to play their historic role of redressing abuse of power, and it would create an incentive for governments to properly train, staff, and equip their police departments. CAC is incredibly grateful for Congresswoman Pressley's continued principled leadership, and we are very grateful for her remarks today.
Hello all, Congresswoman Ayanna Pressley here. I'm so pleased to join you in virtual community today to discuss this critically important topic, the need to ensure justice and accountability in our American legal system. The 14th Amendment to the Constitution guarantees equal protection for all under the law, but we know all too well that our nation has never made fully good on that promise. There are two Americas and two justice systems. From Jim Crow to mass incarceration and police brutality, our criminal injustice system is built upon the fundamental inequities that have enabled and perpetuated cycles of systemic racism for generations. Today, we find ourselves in a moment of national reckoning as we finally begin to more fully unpack and to confront the uncomfortable truths about our nation's past and to examine what can be done to address the hurt and harm they have caused to so many. For too long, Black and brown bodies have been profiled, surveyed, policed, lynched, choked, brutalized, and murdered at the hands of police officers. We cannot allow these fatal injustices to go unchecked any longer. And that's why I introduced, alongside my colleague, Congressman Justin Amash, the Ending Qualified Immunity Act. Our legislation would eliminate the unjust doctrine of qualified immunity, which for decades has shielded police officers from accountability and impeded justice and healing for so many. Qualified immunity undermines the constitutional rights of every person in this country, which is why our bill codifies that doctrine is not grounds for defense for officers that violate the law. Let me be clear, ending qualified immunity is just the beginning of our work to radically reimagine our legal system. But it's a critical first step as we work towards finally affirming liberty and justice for all. I'm so grateful to count you all as thought partners in this fight, and I look forward to our continued partnership as we fight to create a more equitable and just nation. Thank you.
Thank you so much, Congresswoman Pressley, for those moving remarks and for your leadership on criminal justice reform and so many other important issues. And now I am extremely pleased to introduce our panel of experts, including Professor Alexis Karteron, who directs the Constitutional Rights Clinic at Rutgers Law School, Chiraag Bains, who is the Director of Legal Strategies at Demos, and CAC's own David Gans, who directs our program on human rights, civil rights, and citizenship. Our panel discussion will be moderated by Roy Austin, who is a partner at Harris Wiltshire and Grannis LLP. You might know Roy from his time within the Obama administration when he served as Deputy Assistant Attorney General within the department's Civil Rights Division, where he supervised the criminal section as well as the Special Litigation Department's law enforcement portfolio. Or perhaps you know him from his time on the Obama White House's Domestic Policy Council, where he did crucial work with the president's task force on 21st century policing. Regardless of how you know Roy, you'll realize that we are incredibly unfortunate to have him steering the discussion this evening, and I'm very grateful. Thank you, Roy, and I'll hand it over to you.
And thank you so much, Elizabeth, and thank you, CAC, for your incredible leadership in this space, in this work. This is an amazingly important conversation that we're about to have here, because in this moment, in the moment following the killing of George Floyd, we're very quick to blame the police, whether that is the chiefs or whether that is the rank and file. We're very quick to blame the police unions for why we are where we are today. We blame prosecutors. The one group that has been avoided in that blame are our courts. And maybe we need to take a deeper look at those courts and a deeper look at how we got to where we are right now, where there are some real challenges and real questions about the rule of law and whether or not we as a country are using the rule of law in the way it should be used, and whether it is being protected in the way it should be protected. So I look forward to this discussion, and I look forward to having you, everyone here in the audience, participate in this discussion through your questions. But let's start with the expert and our lead article here. So David, why don't you start us off here and talk a little bit about the work that you have done regarding the courts, the 14th Amendment, and the rights of people of color. Thank you so much.
Thanks so much, Roy. I'm really pleased to participate in this wonderful panel discussion on a new piece of scholarship I've written, which is called "We Do Not Want to Be Hunted, the Right to be Secure and Our Constitutional Story of Race and Policing." As you mentioned, in the wake of the killing of George Floyd, Breonna Taylor, and countless others, we are reckoning with our long and tragic history of racialized policing practices and state violence. In this new narrative, I look at how the courts have failed to do justice to our whole constitutional story of policing. Our system of policing is badly broken for many reasons, and one of those reasons is the Supreme Court's betrayal of a critical part of the 14th Amendment. What do the courts talk about when they talk about policing? What do they talk about when they talk about our constitutional story of policing? By and large, they begin and end in the founding era. And this erases the 14th Amendment from our constitutional story of policing. This matters because the 14th Amendment puts race front and center in our constitutional story of policing. Race, police abuse, equal citizenship are front and center in the 14th Amendment. This history tells us that More than 150 years ago, we amended the Constitution to eradicate brutal racial police violence and ensure personal security to all, regardless of race. This is so important because the moment we're in, the moment with George Floyd, we've been in this moment before, and we changed our Constitution because of that moment. The 14th Amendment was the nation's response to the South's effort to strip Black Americans of the promise of freedom that they had fought and won for in the Civil War. And police abuse lies at the core of 14th Amendment history. In this narrative, I detail 4 kinds of police abuse in the record amassed by the framers of the 14th Amendment, and I rely a great deal on original documents, including the very documents that they produced to sell and advocate ratification of the 14th Amendment. So the first is Southern states passed black codes that were designed to strip African Americans of basic fundamental rights, and all of these black codes included vagrancy laws that gave police officers sweeping powers to arrest Black Americans for failing to sign a work contract, refusing an employer's order, or being idle in the eyes of law enforcement. And these were very aggressively enforced, resulting in massive arrests of Black people. These made freedom of movement a sham. Second, police officers invaded Black people's homes to steal their arms, their personal property. They fleeced them of their possessions. Third, there's a huge record of police officers killing and beating African Americans and their white allies. And then fourth, when white mobs terrorized Black people, police officers turned a blind eye. Law enforcement turned a blind eye to that campaign of terror. So the sort of twin harms that we're still dealing with, under-policing and over-policing, are really there at the time of the 14th Amendment. And the 14th Amendment guarantees equal protection of the laws, which in kind of very clear and majestic terms insists that the police have to serve everyone on the basis of equality. They have to work for everyone. And as Congress completes its work on the 14th Amendment and states begin to consider ratification, there are hugely important events. And the police lead brutal massacres of Black Americans in Memphis and New Orleans. And these events really spur the amendment's ratification. And they help convince Americans that the 14th Amendment was needed to break the cycle of brutal racial murder and violence. You know, on one hand, you have President Andrew Johnson, who says, don't ratify the 14th Amendment. This is going to destroy the states. It's going to subject to federal control. And on the other hand, you have the amendment supporters saying, we need to protect fundamental rights. We need to ensure equality in our charter. And these events, in which hundreds and hundreds of Black Americans are brutally killed, women are raped in cold blood, sort of become a touchstone for the amendment to be ratified. And as this history shows, the 14th Amendment was in a very fundamental way about the racial violence that took so many innocent lives in these first few years of emancipation. And the guarantees of fundamental rights and equal protection that are written into the 14th Amendment really embed the idea that Black lives matter directly in the Constitution. They were a response to the brutal murders in Memphis and New Orleans and in so many other places. The 14th Amendment's history should be at the center of the constitutional law of policing, but tragically it has never gotten its due. The Supreme Court has never recognized that the 14th Amendment was added against the backdrop of brutal racial violence. The Supreme Court has never recognized that the 14th Amendment was added against this pattern of indiscriminate and pretextual arrests of Black Americans. So its jurisprudence has a massive blind spot on its foundation. And so rather than safeguarding our constitutional birthright of security, what the court has done is it's concentrated more and more power in the police. It's sanctioned discriminatory policing and racial profiling. It's allowed systematic racial police violence to continue unchecked. And it's gutted virtually every remedy to hold the police accountable for violation of constitutional rights. A big part of that story is the qualified immunity doctrine that Congresswoman Pressley mentioned and that her legislation would eliminate. But that's only one part of a sort of a web of different doctrines that make it virtually impossible to hold police accountable when they violate their constitutional rights and really undermine the rule of law. Protests now in the wake of the killing of George Floyd are really urging us, we've got to take back our Constitution. And for more than 150 years, we've been having really the same fight over the meaning of freedom. There's a through line between Black Americans' insistence at the end of the Civil War that now that we're free, we don't want to be hunted, which is a quote from a really moving letter that Black Mississippians wrote to the governor of the state in December of 1865, insisting that their freedom had to be respected. There's a through line between that and today's demands of Black Lives Matter, stop killing us, and the protests that we've been seeing across America are seeking to give voice to these sort of very basic constitutional precepts of equal justice, bodily integrity that the Supreme Court has long ignored. And so the sort of central point of this article is we can't really fix our broken system of policing without a full understanding of our constitutional history. And we need to get this history right to correct police abuse of power today. And really the question going forward that I'm looking forward to discussing today is how we can use this full constitutional story both in and outside the courts to change our broken system of policing and to help ensure respect for our constitutional promise of personal security for all, regardless of race, which was so important to the 14th Amendment. And with that, I'm going to turn it over to Professor Alexis Karteron to get her perspective on what it would mean to give a holistic look at policing.
Thanks, David. It's such a pleasure to be part of this panel, which is asking us to do something really important, to think differently about the constitutional regulation of policing. Since I've been asked to offer an academic perspective on the ideas presented in David's paper, I'll start by confirming one of the core insights there, that there has been entirely too much focus on Fourth Amendment protection against unreasonable searches and seizures in the legal academy and the courts, and not nearly enough on the 14th Amendment's guarantee of equal protection. So now that David has shared with us the affirmative case for why we should be thinking about the 14th Amendment as relevant to the constitutional regulation of policing, I thought it'd be helpful to look at the conventional story of constitutional regulation of policing, largely through the lens of the Fourth Amendment. This conventional story starts in law school, the only class the average law student has access to addressing the constitutional regulation of policing is a criminal procedure class or two. Typically, there's one course that focuses on criminal investigations and another that focuses on adjudication, sometimes nicknamed bail to jail. In a criminal investigation class, the student learns about the Fourth Amendment and comes away with the following lessons. First, probable cause is required for arrest. Second, reasonable suspicion, a lower standard, applies to stops or temporary detentions. Third, the default rule for a search by law enforcement is that a warrant is required, but there are numerous exceptions to the warrant requirement, and a typical criminal procedure class will spend many weeks covering those exceptions. Fourth, race is basically irrelevant to Fourth Amendment inquiries. Even if a police officer was motivated by racial animus and stopping, arresting, or searching someone, that problem is not relevant to a Fourth Amendment analysis. Fifth, reasonableness is the touchstone of a Fourth Amendment analysis. And finally, it's worth noting that even in these classes, the average law student could easily graduate without learning the Fourth Amendment standards that govern the use of force. This is true despite the obvious importance of the use of force in our public conversations. And even though that's true, it's a topic that's often not covered or taught to law students at all. And qualified immunity, discussed by Congresswoman Pressley earlier, doesn't make the cut. When it comes to policing, the conversation in the legal academy is often far too focused on discussing Fourth Amendment rights in the context of criminal cases and not the experiences of Black people and other people of color that don't always show up in those cases. As read by the Supreme Court, the Fourth Amendment leaves the unique and abusive, all too often, experiences of people of color completely out of the conversation. And that is reflected in far too much legal pedagogy. I'll give an example of one of those policing practices that probably sounds familiar, that it would be very easy to graduate from law school never having discussed. And that's the NYPD Stop and Frisk program. Between roughly 2003 and 2012, the NYPD was regularly stopping hundreds of thousands of people, largely Black and brown young men. One of the most striking statistics of that era is that in 1 year, the NYPD stopped more young Black men than lived in the entire city of New York. So the experience of stop and frisk was racialized very much. And if you were an older white man who lived on the Upper East Side, your chance of being stopped was basically nil. If you were a young Black man from East New York and Brooklyn, an overwhelmingly Black and brown neighborhood, there was practically a guarantee that the NYPD would interrupt your day, force you to stand against a wall, pat you down, probably stick their hands in your pockets, and generally harass you. If you were that young man and you weren't found with marijuana or something else deemed suspicious, you were free to move about your day. But of course, these young men weren't truly free. No one can be when you're subject to random stop by the police, when you're just supposed to be going about your daily business. And it's also worth noting this went on in the street, not just in the streets, but also in apartment buildings. The toll was really significant. I'll never forget meeting a woman who said she didn't want to host Easter dinner at her apartment because she feared that her loved ones would be harassed by the NYPD when moving through the lobby or in the elevator or walking down the hall on their way to her apartment. There have always been some in the legal academy who've been attentive to the real world impact of the Supreme Court's extraordinarily cramped view of constitutional protections for people, especially Black people and other people of color, under the Fourth Amendment. Many, like Devin Carbato, Paul Butler, and Tony Thompson, are cited in David's wonderful piece. I'm hopeful that this new academic article and the advocacy of the Constitutional Accountability Center will launch a new conversation involving many new voices about the meaning of the Constitution in all of our lives with regard to policing, race, and equality. Now I will turn it over to Chirag to discuss the practical implications of these constitutional standards in the litigation and legislative contexts.
Thank you, Professor Karteron. It's a pleasure to be with you. Again, my name is Chirag Bains, and I am the Director of Legal Strategies at DEMOS, which is a policy and advocacy organization that fights for the liberation of Black and Brown communities. And we here, as we're sitting here on this webinar, we're in the midst of what is now the largest social movement in American history. It's a movement of nationwide protests in defense of Black lives, a movement that has made police violence and systemic racism kitchen table issues for all Americans. David's contribution in his paper, as I read it, is that the existence of that violence and systemic racism is due in part to the decisions of the Supreme Court, which have largely escaped general public scrutiny, as Roy mentioned at the top of the hour. And specifically, its failure to take seriously the Fourth and the 14th Amendments. And when I think about the recent high-profile killings and murders that we have all been talking about, I see connections to the doctrines that David talks about. I'm going to give a couple of examples. The murder of George Floyd, for example. George Floyd was arrested for allegedly using a counterfeit $20 bill. That implicates the doctrines that David discusses on there being no need for a warrant anymore to arrest people in most situations. The almost complete move away from the warrant requirement for arrests. It recalls for me the Atwater case that he cites, where the Supreme Court allowed an arrest for a fine-only offense. A woman who didn't have her seatbelt, didn't have a seatbelt on her children. She was taken to jail for that. I think about Sandra Bland's case as well, being taken to jail. These are situations where they don't seem to call for arrests or any force, and yet they result in people being murdered or killed. Thinking about the Breonna Taylor situation, Breonna Taylor's experience as well with no-knock warrants. The Supreme Court has allowed no-knock warrants when there's reasonable suspicion that it would be dangerous to knock. The Supreme Court has said that even where a knock is required and police do not do so, they can still use the evidence. The exclusionary rule doesn't apply. And that has actually removed the deterrent effect of the knock and announce rule. So police don't have an incentive to follow it. And we saw in the situation of the killing of Breonna Taylor that situation, I think, could have been avoided had there been stronger rules in place about when police can enter someone's home without notice and when they cannot. I think about the situation of Tamir Rice, a 12-year-old boy who was killed in Cleveland, Ohio, when he was playing with a toy gun in a public park. The Supreme Court has, in a couple of recent cases, declined to extend even the reasonableness analysis that David discusses in his paper to more than the moment in which force is used. So if you're looking at the moment in which the officer, Timothy Loman, shot and killed Tamir Rice, you might say, well, it was reasonable. He saw what looked like a real gun. But if you were to zoom out and then look at the sequence of events, you would see that the officer drove right up to Tamir Rice, opened his car door right next to him, and within 2 seconds shot and killed him. And that kind of analysis, right now, the Supreme Court has not permitted, it has not allowed that kind of larger, wide lens analysis of the sequence of events. And I think the consequence ultimately is that even in situations where black letter law tells us that conduct is unconstitutional, we still see that conduct take place. And here I'm thinking about the federal presence in Portland and the fact that federal agents or federal officers have been arresting people without probable cause. It's very clear under existing Supreme Court doctrine that you need probable cause to arrest a person. Even if you don't have a warrant, you still need probable cause. And yet there are videos of officers taking people off the street and putting them in one famous video in a van and taking them away. That's an arrest without probable cause, without any particularized suspicion that rises to the level of probable cause that a person has committed a crime. And the erosion of rights is so thoroughgoing that we see the Attorney General of the United States telling Congress that he thinks there may well have been legal basis for the conduct in Portland. So what do we do about it? We've seen this kind of widespread erosion of rights. It's documented in David's paper. How do litigators and advocates respond to this environment? A couple of thoughts. One, I think about institutional structures. If there are weaknesses in the law, what are the institutional structures that we can put in place to try to work around those and achieve justice despite the many barriers that, say, private plaintiffs face of the sort of standing, like in the Lyons case, which is the chokehold case from LA that David cites, or in the situation of qualified immunity, where people are not able to get remedies against individual officers because of the doctrine of qualified immunity. One institutional structure is the Justice Department's pattern or practice cases. I hope we'll have some time to talk about that today. The Justice Department doesn't face the same procedural hurdles that private litigants do, and under the Obama administration, where some of us served, the administration brought 25 investigations of police departments. We've seen a move away from those kinds of cases, but they do offer some promise, and I hope that we'll bring those back. We also should think about institutionalizing that kind of effort at the state level. So far, there are only a few states that do something similar, and very infrequently. That can be a more widespread practice. The second thought here is litigation may be fruitful at the state level. The Supreme Court has closed a lot of doors, but state Supreme Courts have the power to interpret analog provisions in their constitution, equal protection, for example, to be broader and more protective than what the Supreme Court has said of the federal Constitution, of the United States Constitution. For example, 3 state Supreme Courts have already found that pretextual stops violate their constitutions. And the New Jersey Supreme Court has found that consent searches, which have been approved by the US Supreme Court, violate the New Jersey Constitution. And then the third area that I would highlight here is public policy. The Supreme Court is interpreting the Constitution. The Constitution sets the floor on what kind of protection we get in our interaction with police. Legislation can offer more protection. The Justice and Policing Act is pending in Congress right now. It bans chokeholds, it bans racial profiling, it prohibits no-knock warrants for drug offenses. Congresswoman Ayanna Pressley mentioned earlier that she has a bill to abolish qualified immunity. And we can do more here. We can trim the federal code, we can trim the state codes. I would think about the legalization of marijuana, a drug where enforcement around marijuana has been wildly disproportionate in terms of focusing on Black people. And that's something where we can actually change the code. I would think about what the arrest power is, when are arrests permissible? And then I would think about investing in alternative forms of public safety. We don't need police to respond to every situation. In some cases, we need social workers, public health professionals, and others who can diffuse a situation, who have specific training. And these are all demands that I think communities can make of their local governments, their state governments, and of the federal government. And with that, I'll turn it back over to Roy.
Thank you so much, David, Alexis, and Chirag, for your comments. And let me just say that for those of you in the audience who have questions for the panelists, you can submit your questions online and we'll try to answer them at the end. If you're watching via CAC's Facebook or YouTube channel, you have to be logged in to submit a question. If you're watching through CAC's website, the stream is being fed to you via YouTube. Just expand your browser, log in, and submit your question. So let me start with David, and hopefully I can have all of the panelists join me for this discussion. I'm going to start with David, but certainly if anyone has something else to add, I'd love to have people just jump on in. It's real easy for all of you to talk without anybody asking questions, but I need to ask you guys some questions. So David, you talked about about the courts and the problem with the 14th Amendment. Has any justice got it right? Are there any opinions out there, dissents out there, where the justices actually get what you're saying here? I mean,
there isn't really sort of a golden age of constitutional jurisprudence that has gotten it right. I think many of the problems, even in the Warren Court, which is often sort of the heyday, there isn't a great body of Warren Court doctrine that got it right. There's some important early decisions, but Terry versus Ohio, which is the case that sort of says stop and frisk is okay, we can dispense with probable cause and allow stops on the basis of reasonable suspicion, even though the court is aware that will sort of license racial harassment. That's in the Warren Court. I think there are justices who have gotten it right. I think there was a very prescient dissent in Terry by Justice Douglas that sort of says this is fundamentally changing our constitutional system to allow stops on the basis of less than probable cause. I mean, you can look at today, you can look at Justice Sotomayor, who is really the leading voice on the court, that says we need to enforce our Constitution and prevent systemic racism and racialized policing practices. You can look at, the dissent she wrote in a case called Utah versus Strieff, which was a case about whether the exclusionary rule applied in the context of a lawless police stop where an individual was stopped without any basis of suspicion. And then on stopping him, they found drugs and ran a warrant check. And then he was convicted on the basis of that. And the court said, that's fine. Justice Thomas said, this is just negligence that can come in, even though this seems like a pretty clear constitutional violation. And Justice Sotomayor speaks kind of very powerfully about allowing the police to stop you, even in a flagrantly unconstitutional way, if there are no remedies for that misconduct. And she talks about how this opens the door to racialized policing practices. She talks about sort of this leads to a denial of basic equal citizenship. Many of the arguments that myself and other scholars have developed. So there are justices on the Supreme Court who have recognized some of these fundamental points. There's let
me have Alexis jump in here 1 second, David. And Alexis, here's my question for you: is this using kind of 14th Amendment language? Is this intent, or is this disparate impact? So are the judges intentionally doing things that they know are going to harm Blacks and people of color, or is it just a matter of disparate impact that we're seeing?
Yeah, that's a really good question. I think it honestly probably varies. I think one of the things that's interesting is when you look at litigation around these issues, around police practices, you occasionally have cases where the plaintiffs are able to prove that intent was at play, discriminatory intent was at play, but often it's extraordinarily difficult. So to take the stop and frisk example again, the plaintiffs in the stop and frisk case, and I should disclose I worked on a related case, not the main one, but in the main case, Floyd, the plaintiffs were able to prove that. And it basically came down to both the data, which showed incredible disparate impact on Black and Brown communities, and also a meeting between the NYPD commissioner and some state legislators where he said something to the effect of that he wanted to stop Black and Brown youth to deter them from carrying guns. But if there hadn't been that meeting, if there hadn't been those state legislators who were willing to come to federal court and testify, it's hard to know if that finding ultimately would have been made by the district court. So, I think we all, especially in these days, are well aware of rampant intentional discrimination, but proving it up is just so extraordinarily difficult that it's become a huge barrier to using the 14th Amendment effectively in light of the current jurisprudence.
Thanks, Alexis. Chirag, President Trump is about 200 new judges. Should we really even care to take our disputes to the courts anymore? Do we expect a good result to come from that? Or how do we move forward here, given the landscape of our courts?
Roy, I wouldn't overinvest in federal court litigation strategies on these issues for the reason that you describe. It's partly that President Trump has filled the courts with quite conservative judges. It's also that the Supreme Court's doctrines have almost all gone in one direction on this. I think this is well documented in David's paper. It doesn't mean there's not room for creative federal court litigation. I think there is some. I think actually the qualified immunity doctrine is one that there may well be room for the Supreme Court to undo that doctrine. That's a judge-made doctrine. It was created essentially in 1982 as a gloss on Section 1983 litigation. That that not only do you have to prove a violation, you have to prove that it's clearly established, and which the way it's gone, David should correct me if I've got this wrong, but the way it's gone is that you essentially need to find another case on point, just like that, facts that match your case, which is extraordinarily difficult and limiting. That's a doctrine I think the Supreme Court could undo, and I would continue to press on that. There were 9 certifications pending this last term, and the court didn't take them up. But that's why I emphasized in my opening remarks the need to look for other strategies as well, state court strategies, policy, legislation, and seeing legislation as the ability to give us greater protection than the Supreme Court is giving us through the Constitution. I also would say that we should pay attention to this issue of the courts. It matters who is president. It matters who gets on the courts. We should be seeing more people with direct experience with the criminal system at the receiving end of the criminal legal system, as well as public defenders, legal aid lawyers on the bench. I think if you have more folks like that on the bench, you're more likely to get judicial rulings that more accord with public sensibility on what should be constitutional and what shouldn't.
So, Chirag, let me stick with you for a second here, and you mentioned what was happening in Portland. So, who would you rather have interfere with your rights, federal law enforcement or state law enforcement? Who's your favorite?
Roy, I'm going to ask you to repeat that. I had a little technical issue here with.
Sorry.
Could you do that, please?
Yeah, I was asking who would you prefer to have violate your rights, federal law enforcement or state law enforcement? Because we seem to be complaining about the fact that federal law enforcement is in Portland, but we also know that what we saw in Seattle was a lot of state law enforcement. So I guess which one would we prefer to have violate our rights?
Well, I'll fight the hypothetical or the question to the extent that that's, I think, not the question we should be asking. We should be asking, should any of this be happening in the first place? Both should be our problems, and there should be liability for both. I mean, as a technical matter, I suppose I'd prefer to have the state violate my rights so that I can actually sue them under Section 1983, because otherwise I'd have to prove a Bivens action, and the Supreme Court has really been clamping down on Bivens. And although I would try to make the argument that what's happening in Portland falls squarely within Bivens, which, just for the audience's sake, in case hopefully we have some non-lawyers on the call, it is a judge-created doctrine, a Supreme Court-created doctrine to allow lawsuits to be brought under the Constitution directly. There's no statutory vehicle to do that. So I guess for that reason, but I think we need a different conversation. What should policing look like? And shouldn't there be remedies across the board? A federal Bivens statute, since I've gone this far down this road, Roy, I think would be helpful. There should be an equivalent to 1983 for when federal agents violate your rights. There should be just a general private right of action for excessive force.
Alexis, you were talking about stop and frisk and very successful lawsuit there, but I mean, when stop and frisk came to be, and it's kind of the close cousin of broken windows under Rudy Giuliani, there was a lot of really violent crime happening in New York at the time. And I mean, shouldn't we give credit to broken windows for having brought that crime down to make New York as safe as it ended up being?
Absolutely not. And I say that as a native New Yorker and someone who has spent a lot of time studying policing in New York City. I mean, I think it's fair to say that there's really no clear proof that broken windows led to the decline in crime in New York City. Crime declined really all over the country at roughly the same time, for reasons that still puzzle criminologists. One thing I've learned over the years is to always talk to the criminologists, not always the lawyers, because they often have the answers and are doing more rigorous studies than we ever do as lawyers and litigators. So I personally would I would not give credit to broken windows policing for bringing down the crime rate in New York City. And, in part that's because of what we know about what happened with stop and frisk. Stop and frisk, you said, was a close cousin. That might even be too far a connection. I mean, it was really very much a direct descendant of broken windows, a continuation of the broken windows tactics that started in the Giuliani era. And, throughout the debate around stop and frisk in New York City, there was always this claim from Mayor Bloomberg, who fought very, very, very hard against any kind of inquiry into what the NYPD was doing, that if you brought down the stop and frisk numbers, crime would go up. And it just didn't happen. We can look back now. It's hard to believe that it's been 7 years since the big stop and frisk trial in the Floyd case. And, even going back years further than that when the litigation actually started, and it just hasn't panned out. So, no, you will never hear me say that we owe a crime reduction to broken windows. But I think it's actually a good tale of why we always need to be questioning, what police are saying, what they're telling us about what is necessary for our safety. And as Chirag said, we really need to be kind of rethinking what we want policing to look like. How do we define safety? How do we define, a really progressive movement forward so that we're not subject to police violence as we are all too often?
David, the Supreme Court had a chance to take a close look at qualified immunity. They had 9 cases, I think, is what Chirag just pointed out, and they passed on it. Why did the Supreme Court not take this opportunity to take on something that even Justice Thomas seems to think is kind of a joke?
I mean, so they should have taken it on because there's really no basis in basic legal interpretation in the qualified immunity doctrine. This is a doctrine the Supreme Court really invented out of whole cloth. And if you think about, I want to bring it back to the sort of 14th Amendment story and this point that I've been making, that the court is just erasing the 14th Amendment from the story of policing. If you think about the 14th Amendment is ratified in 1868. Section 1983 is added in 1871. There's virtually no constitutional jurisprudence around the 14th Amendment at that time. So the idea that the Supreme Court insists now that to sue under Section 1983, you have to show a violation of clearly established law kind of would have strangled the statute at birth. There was no law of any kind at that time. The courts were just beginning to interpret the 14th Amendment. And, in the decades after 1983 was passed, there were some great wins. There were also some huge tragedies, but it was more or less a blank slate. So the Supreme Court's idea that you have to show a violation of clearly established law is really just making a mess of the text. This is kind of a very basic conservative idea. You follow the text, you don't write things into the text. Why did they? Perhaps I think sort of the one possibility is Congress was beginning to reconsider qualified immunity. There are bills before it when the Supreme Court denied cert. They wanted to see, is Congress going to act? I'm not. I mean, I think it was very disappointing to see.
But David, did they really think Congress was going to act? When does Congress act? Sorry,
I mean,
rhetorical.
That's sort of a fair point. This is, I think, a huge injustice in which the courts have rewritten a fundamentally important statute designed to hold state officers accountable when they violate your constitutional rights, and they've rewritten it so that it's friendly to those state officers. They've made a critically important federal statute that was designed to ensure the promise of freedom at the core of the 14th Amendment to immunize lawbreakers. So they've really done violence to the statute, and I think these cases are not going away. You are going to see year after year more cases coming to the court, and I am hopeful the court will recognize this is a basic injustice that prevents the enforcement of constitutional rights and can't really be squared with the rule of law and with kind of basic principles of legal interpretation, which emphasize courts can't do violence to the text because they have a policy preference.
So David, let me jump to Alexis 1 second. So Alexis, technically speaking, more white people are shot and killed by the police each year than black people, and yet this, the marchers out there are shouting that Black Lives Matter. Are the marchers getting it right, or is it just that the police in general need to be better about how they treat lives?
Well, I think it's, well, first I'll say, yes, the marchers are getting it right. Second, I'll say one thing to keep in mind here is that this is an area of massive under-regulation. So what we know about the number of people shot by the police comes not from any kind of mandatory reporting that the police do. It comes from places like the Washington Post deciding that they are going to dedicate tremendous resources to tracking every killing by police in the United States. I feel like that's important to mention because it really just kind of sets the stage to understand how much we have not been paying attention in an important way to what the police are doing and what their activities are outside of criminal cases. So if a person is killed, obviously they can't be brought up on criminal charges. And that's where so much of our attention goes into the court process. But I will say, I think that we do know that there's a long history of a disparate impact on communities of color. Even though the total number of people killed by police, there may be more white people killed than Black people in the United States. There are way more white people in the United States than Black people. So the disproportionality is something that has been of great concern, as David's paper points out, for 150 years, if not more. So we really need to remember that as we look at these issues and continue to press for more regulation, more oversight of what the police are doing, because we frankly have been blind to it for far too long. And these things vary too much city to city, state to state. We don't even really have a really clear picture of so many policing practices around the country.
Thank you, Alexis. Chirag, in the Breonna Taylor case, who should be charged and with what? I think you're on mute still. Are we frozen? Sorry. Chirag, I'm showing you're still on mute. Oh, there you go. Did you hear the question?
Yeah, I was frozen for a moment, but I'm back.
Okay. In the Breonna Taylor case, who should be charged and with what?
Well, the offenses that are available would be federal or state charges that go to essentially violation of her civil rights, as well as essentially force or violence charges that could be available against officers when they don't have a legitimate defense. So the question you always ask in these cases is, okay, police used force against someone. Did they have justification to do so? If not, that's a violation of their rights. So in this case, the officers who shot and killed Breonna Taylor could be charged. They could be charged with federal offenses. There's a challenge there, though, I should point out. One is that under federal law, there's one statute, came out of the Reconstruction era. It is a product of, I believe, the Civil Rights Act of 1866 in its original form, and it requires that federal prosecutors prove that the defendant willfully deprived the person of their rights under color of law. And it's the willful part that's the hardest. So you have to prove there's a violation of rights. You have to prove that it was done under color of law, but you also have to prove that it was willful, which the Supreme Court has essentially held means that the officer knew what they were doing was wrong and did it anyway. And that looks pretty close to first-degree murder. So candidly, it's a pretty tough charge to bring in a situation like Breonna Taylor's. The Supreme Court also makes it hard because the Supreme Court in this case has said that deprivation of the deprivation of rights gets to what is the content of your Fourth Amendment rights. So the substantive rules around when officers can use force and the comment I made earlier about when you examine reasonableness are pretty expansive. They're very deferential to police officers. Under state law, though, you have some of that imported. That's one of the challenges. State law has tended to import these kinds of justification defenses for police officers using Supreme Court law. There's a lot of language in Supreme Court law around giving officers the benefit of the doubt, the not judging them based on 20/20 hindsight, considering that they have to make these kind of split-second judgments under often tense and rapidly evolving situations. That's not always the case, and yet it shows up in every defense of these kinds of criminal charges. So there may well be state charges available here, but you'd see some of those same defenses. And the reason I bring that up is I think it comes back to we do need to change some of these doctrines over time. The Supreme Court does need to come out differently on what is the content of your constitutional protection under the Fourth Amendment and 14th Amendment.
Thank you. Let me go to some of the questions from our audience. And David, one of our audience members asked, for qualified immunity, what would we replace it with if we got rid of it?
I mean, I think the replacement is, which is just following the text of 1983. So you could take a police brutality case. If the police use excessive force in a manner that is constitutionally unreasonable under the governing doctrine, they would be held liable. And virtually all of the time that would mean their employer would pay, because police almost all of the time in police misconduct litigation are indemnified. And so, I'm not sure it would change that much. You now you have, in many ways, this triple protection. One, you have these standards that Chirag mentioned already build in the possibility that police might make a mistake by sort of saying, we're going to judge reasonableness in the excessive force context by looking at the perspective of what a reasonable police officer would do. So mistakes are already built in there. Then on top of that, now you have qualified immunity, which says we're going to protect that even more by insisting that you can only be sued if there's a case on point, if the law is so clear that this was a no-brainer. And then the third level of protection is that across the board, states indemnify officers, and they represent them. They pay the underlying judgment. So part of the problem is you have a system that overprotects three ways concerns that officers might get it wrong, and doesn't protect at all the basic constitutional interest in preventing brutal conduct by the police officer. And these are doctrines that are really out of whack with the history. These are doctrines that don't take seriously that police violence was at the heart of the 14th Amendment. And if you look at that history, I think you would, and honestly try and create doctrines that protect it, you would have a much more rigorous analysis that would make sure you're checking police violence, not sort of opening the door to the systemic police violence directed at people of color that we've seen time and time again for decades, for centuries.
So Alexis, we have a question about schools and police in schools. And how does this analysis work with respect to schools where isn't the point to keep students safe? And how have we ended up in a place where where we see communities saying that they don't want police in their schools anymore?
Mm-hmm. Yeah, I'm really glad that someone asked about that, because it's an issue that I think is really important, that is all too often overlooked when we're talking about policing. We think about interactions with officers when people are walking down the street, maybe when they get arrested. But really for a lot of kids, particularly kids in poorer environments, their interactions with police start in school. There are some school districts where there's at least one officer in every single school. Sometimes they're security guards, sometimes they're sheriff's deputies. And these headlines, they come every once in a while, but the sustained attention really hasn't been there. In terms of the history and what the history tells us, it's interesting because it really is that police have not historically been in schools. The police presence in schools really took off after the massacre at Columbine in the 1990s, and has really kind of been a runaway train until, I think it's fair to say, this summer, when suddenly we've seen all this movement away from police in schools. Because we know, unsurprisingly, that when police are in schools, again, criminologists, they tell us this, when police are in schools, that's when you see a lot more regulation of kids for minor things that, otherwise would never result in a trip to the station house as opposed to a trip to the principal's office. So I'm glad someone asked it, and I implore all of us to remember policing in schools as we talk about the role of police in our society.
And Chirag, a question from our audience is on social workers and the idea that we need to have the social workers go into a lot of these situations. But having known a couple social workers, I'm not sure that they want to go somewhere where you have a man or a woman with a gun or a knife waving it around. How exactly is that supposed to work?
Well, that's not the proposal that's generally being discussed right now, right? The idea of having non-police responses is for situations that don't call for, that don't involve like imminent violence, the kind of situation that you just described, Roy. I think the movement that we're observing right now, the movement led by Black activists, which has become a multiracial movement, is saying we don't need police to respond to every problem that we have in society. And some studies show that police departments spend something like 4 or 5% of their time, police officers, on rapes and murders, investigating or prosecuting or stopping those offenses. There's a lot of other work involved in being a police officer. Now, some of that is going to court and doing paperwork and so forth. A lot of it is this kind of order maintenance policing that Alexis talked about, Professor Karteron, with regard to the NYPD stop and frisk case. Schools is another good one, I think, that the professor talked about. That's a situation where there is no evidence. There's zero evidence that police actually improve public safety in schools. Most evidence shows that the presence of school resource officers produce no safety gains. Only once has a police officer in a school stopped an active shooter situation. There is evidence that the presence of police in schools has reduced academic achievement for students and has helped fuel the school to prison pipeline. So the idea here is sort of globally, where do we actually need that kind of crime fighting force? And if the situation is one that really calls for a conversation, de-escalation, someone who's a trained mental health professional who could help a person who's in crisis, then perhaps we should send someone who's trained in that. Right now, we only have one service that answers the phone 24/7, and it'll send someone out to your home or wherever you are, and that's the cops. And that's not fair to us or to the police officers. They're not equipped to do all of this. And the idea here is to set up alternative services to provide the kind of support that people really need in the vast majority of these kinds of disputes.
So I'm going to ask David one last question, since you're the one who wrote the paper here, and then I'm going to ask all of you a very quick question. But David, a question from the audience again. A piece of scholarship this comprehensive surely was in progress long before this conversation gained increased national attention this summer. Has the conversation our society has been having more broadly in the past few months changed or add nuance to any of the views in your paper? And if so, how? And I'm only going to give you about 20 seconds to answer that so we can jump to our final question.
I mean, what it's opened up is a room for debate about solutions. So you can think about Representative Pressley is already putting on the table Congress needs to end qualified immunity, and Congress has powers to enforce the 14th Amendment. And so Congress can take what I've laid out, that race and police abuse and equal citizenship were at the forefront of the 14th Amendment, and they can think about passing legislation to enforce those rights. That's something that would would not have been on the table, I think, until very much recently.
All right. So sorry. So we are running out of time. So David, I'm going to cut you off. I apologize. Real quickly, I'm going to start with you, David. Defund the police. Truly defund the police. Yes or no? You got one sentence to answer that question.
I think the question is, what do we want the police to do, and how can we make sure they do it in a way that respects fundamental constitutional rights?
Chirag, do we defund the police? Yes or no?
The hard part of it, yes or no, is that people mean different things by defund the police. My answer to the question is we absolutely should have that conversation. It shouldn't be taboo. Where we spend our money is a reflection of our values and our theories on how to actually bring about public safety. So I say yes to this conversation. It's urgent.
Alexis, final word. Defund the police, yes or no?
Yes, because to me, defund the police means that you're making an active decision to divest from services or departments that are harming our community or pose a risk of harm to our community, and invest in others that can really transform public safety.
Well, I just want to say a huge thank you to you, David, for this piece of scholarship, to you, Alexis, for your longtime work in this space, and Chirag for your leadership on these issues, both in the government and outside of the government. And obviously a huge thank you to CAC for bringing us all together for this conversation. And with that, I believe that Elizabeth is going to join us to say bye to this amazing audience that we've had here. So Elizabeth?
Thank you so much, Roy. And thank you to Chirag, to Alexis, to David, for a wonderful conversation that spanned from the founding to the most urgently pressing questions of today. For more, I urge you to look at our website for the Constitutional Accountability Center, theusconstitution.org. Follow us on Twitter and Facebook, and let's continue to have these important conversations. Thank you so much for joining us.